Hello to everyone who's already online. We're just going to do a sound check. So just want to make sure that people can hear me okay. If anyone has trouble, please just send a message through. And I'll just look to Grace now to make sure she can hear me. And we'll get started in a couple of minutes. So again, just checking everyone can hear me okay. Just send a chat message through if anybody has trouble hearing. Okay, all right. Well, we'll get started in about 2 minutes. And we'll get started. Okay, I'm speaking again for somebody who's trying to hear. At any time, if anybody can't hear, just send a message. I'll try to keep an eye on the messages so that if anybody has trouble, I'll hear that.
Phone is still on hold. Not sure what that means. What did we do last time? It might be working.
Okay, so some people can't hear me.
I'll give them a shot.
Yeah, we might just check with the conference. It seems to be the phone that's not working, whereas if you're on the actual web session, it appears that that sound is working. I'll just try and keep talking a bit, just so that we can test the audio. Is that any better? Now I'm very loud, I think. Okay, that people are saying that's much better. Okay, great. All right, well, it is 12:01, so I might get going. So welcome to today's, just bear with me, we actually have the, just put the other slideshow up. Okay, so welcome to today's webinar. We're talking about E.Discovery and E.Courts and how to prepare. So welcome everyone. I'm sure we'll have other people join. So this session is being recorded, and I will refer to some white papers throughout the session which back up some of what I'm saying. So the recorded sessions and the white papers will be available sometime after this session as well. Okay, so just an overview of what we're going to talk about for the next 40-45 minutes or so. I'll just give you an overview of who eLaw is and who I am, and then we'll talk about electronic discovery. So what is e-discovery? Why would you want to discover documents electronically? What do the courts say? What are the standards in this e-discovery industry, if that's what you like to call it? How to find what's relevant, and then we'll just spend a bit of time looking at technology assisted review. I won't spend too much time on that because we do have other webinars where we just spend 45 minutes or so talking about that. So if you're interested in that, just let us know and we'll let you know when the next webinar on technology assisted review is being conducted. Then we'll talk about electronic trials. What are they? Again, what do the courts require? When would you use an e-court? What do you need in an e-court? And then how to manage the evidence. And then coming out of that, if you'd like further information or a demonstration of how the evidence management systems work, then you can let us know as well. And then finally, just a bit of a discussion about what the courts of the future might look like. So about myself and e.law. E.law was established in about coming up to 16 years ago now, and then recently we merged with another company called Systematics. So between e.law and Systematics, we actually have several years. I hate to say how old we all are by revealing the exact number, but we've all been involved in very large e-discoveries and electronic trials, certainly over the last 16 to 20 years. Some of the key cases that we've been involved with include some of the big law commissions, HIH, All for Food, some of the big litigation matters, C7, and air cargo matter, which was last year. So yeah, I guess hopefully we have some more stories about e-discovery and can give you some of the benefits of our experience in that area. So electronic discovery, what is it? Essentially it's discovery of documents in electronic format. In the early days, and of course you're still going to have a number of hard copy documents that need to be converted to an electronic format. So that's scanning in documents and then capturing some metadata about the document so that that data can be used in a database in order to search across, say, dates, authors, recipients, doc types, things like that. And the court practice notes, each jurisdiction does have a court practice note about how to handle electronic discovery. So depending on whether you're in the federal or any of the state jurisdictions, in the white paper that we'll distribute after this, we'll have each of the court practice notes listed. Now when it comes to discovery of electronic documents, we talk about discovering them in their original native format, and I'll talk a bit more about that. Now I'm going to cover, I guess, both the basics here for those of you who are just new to e-discovery, and hopefully a bit more complex stuff for those of you who've done an e-discovery before. So please bear with me if you've heard some of this before, but I'm just trying to, I guess, cover all bases for the audience that we have. So the question why discover documents electronically, it's simply because almost all evidence today is created electronically somewhere. Email is now a standard form for correspondence. Word processing documents are created and then distributed as attachments to emails. And of course they may be printed out and sent on in hard copy, but essentially they are created in electronic format and often stored in electronic format somewhere at some time. A lot of the discoverable material, as I mentioned, are on email servers, on file servers, but now we're getting more and more information being stored on servers in the cloud. For those of you who are not quite sure what the cloud is, essentially it's where servers are now rented from cloud providers. So instead of having a server room in your office where all of the office files will be stored and located essentially within your office, now it's becoming much more cost effective and even, I guess, even more secure to put your information out in the cloud, assuming that certain security and local jurisdictional issues are covered off by a cloud provider. What that means is that the cloud provider can make best use of those servers because they're now renting out, say, let's say it's a 10 terabyte hard drive. They can split that up into a number of different, what they call virtual machines, rent out that space, and different users can come in and rent space of that server and actually get it usually in a more cost-effective way than having to buy servers, buy infrastructure and then buy people to continually look after hardware that sits in your office out the back. So of course electronic discovery these days means that you may still have to get information off your client's email server, and that could be anywhere. It could be in their office, it could be in the cloud, it could even be somewhere overseas. I won't talk about social media today. Again, we do have webinars where we focus just on social media and some of the evidentiary issues that flow from using or needing to discover information on social media servers. But I'll just point out that that information is discoverable, and if you do have occasion that you do need to obtain it, then just be aware that it's not necessarily sitting on a server at the back. It is sitting with the social media provider, and it could be in another jurisdiction. Now, at the moment, we're still faced with, in discoveries, a lot of documents are simply printed out for review. Now, that's fine, I guess, as long as the native original is retained somewhere. So notwithstanding that the best evidence rule has been abolished under the Evidence Act, you still need, if you need to, go back to the original documents, and the main reason is because an electronic file is much more than its printout. There is a lot of metadata in the electronic file, in the electronic native file, which exists, which could be relevant to your case, such as dates. When was an email sent, when it was received. If there's a question mark over dates and times, you may need to investigate that further. So, don't discount the fact that you should always try and retain the original if and when you can. So the Federal Court and the Supreme Court practice directions in particular, a couple of them actually say printing electronic documents is a waste of time and cost and rarely necessary. As I mentioned earlier, printing means you lose the metadata, and it also means you lose the ability to search across the documents. And this is hugely powerful. So notwithstanding that with electronic information, typically you get a larger volume than you would have compared to hard copy, you do get the power of being able to search across those electronic repositories. And search these days is much more than a simple keyword search, and I'll talk a bit more about that shortly. So what do the courts require? Why do we go through this discovery exercise? Well, essentially documents must be relevant, and then some jurisdictions talk about discovering documents only after conducting a reasonable search, and I'll talk a bit more about this. As mentioned earlier, we've written a white paper on discovery and what the courts need, and we set out the court practice directions, as I mentioned earlier. So we'll make that available when the recording is available as well. Essentially, I won't go through each of these in detail. I've set them out on the slide so that depending on which jurisdiction it is, you have the relevant court rule that allows each party to make or request discovery. Bear in mind that in New South Wales there is the practice direction, the equity division, which provides that you must put your evidence on before you can seek an order for discovery. Now that list is generally managed by Justice Hammerschlag, so if you do require some sort of order for discovery, then you'd need to make an application to the list judge in order to get that order made. Other jurisdictions, there's generally scope to seek discovery. In the Federal Court, it's only after a reasonable search of the documents has been done by a party, and the documents must be directly relevant to the issue in the pleadings. Now, I've set these out because some of them are slightly different. So, for example, in just let me go to the next slide. So in ACT, for example, the documents are discoverable if it relates directly or indirectly to a matter in issue. Now that is a much broader requirement than these requirements that are set out in the Federal Court rules and some of the state rules. And in fact, I think New South Wales was certainly changed in 2005 to narrow that discovery reach. So as I said, I've set out each of the particular rules in each jurisdiction there, and they will be listed in the white paper as well. Now, before I get into, I guess, the detail about searching and technology-assisted review and so on, electronic discovery has actually been around for quite a long time, and particularly out of the States, there's quite a large industry around electronic discovery, simply because the volume of documents they get from a lot of the clients are just huge. So the technology, as I mentioned, is getting increasingly better. There are committees that just specialise in testing some of these technology or these tools, and there's several papers written about on the best way, and this will continue. So I think over the next few years we'll certainly see an increase in the amount of academic papers written about searching for discovery purposes. But essentially this diagram I have up is what we call the electronic discovery reference model. Recently, on the left-hand side, you'll see information management. That was added last year because it means that as a lot of organisations, I guess, have been through the litigation process, they realise that there is huge value in ensuring that their information is managed adequately and properly within their organisation, so that if they do get hit with a discovery order, there's not these huge costs involved in preparing it, reviewing it and providing it to the other side. So as you go through the process of identifying what you need, collecting it, processing it, reviewing it, producing it, and then ultimately presenting the evidence in court, you'll see that the yellow triangle on the left-hand side called volume decreases, and the grey triangle on the right called relevance increases. So that's what it's all about. So those standards are there to help litigants find documents that are relevant among large data sets. And these days, a large volume of data is not necessarily uncommon, even for claims that are relatively small. But as I said, the benefit is that search tools are getting better and better. Recently, that EDRM has been updated to increase the use of sampling. Now, I won't talk too much about that. As I said previously, there is a whole seminar on this whole area of sampling and analytics and technology-assisted review. But essentially, there's a lot of guidance and testing and suggestions about how you can improve your accuracy rate when using some of these search tools to find what's relevant. So to assist in locating relevant documents, as I mentioned previously, keyword searching can be limiting simply because it can be over-inclusive, or it can return a lot of false positives, or it may just miss things. You may not have the right keyword, or you may simply not know what you're looking for at the beginning of a litigation. So that's where technology-assisted review can really help. Now, technology-assisted review, or TAR as we sometimes call it, can cover a number of things, and I'll talk a bit about each one and what they do, and hopefully just show you some examples of how they work so you can see the power of this stuff. So there's concept searching, predictive coding, clustering, categorization, email threading, and near duplicate detection, and they can all be used together interchangeably and so on. And the idea behind them is that you get groups of documents together that are similar or about the same thing, or they may be an email thread, so that compared to the traditional linear view where you'd start at document 1 and then someone else in the team may come across a document that's similar 3 days later, but they're on opposite sides of the room and don't know that in fact they're looking at the same sort of documents, won't make that correlation. So the idea is if you can get one person or a finite group of people looking at documents that are about the same thing, then that should increase the accuracy of your review and hopefully decrease the time it takes to get through a pile of documents in order to actually locate the ones you do need to discover and ultimately present in court.
No.
So technology-assisted review, it can work in conjunction with keywords, but it just opens up a whole new realm for you. And as I said, it's there to assist human review. It's not there to replace human reviewers. And the whole purpose of this is to try and find the relevant documents. I mean, not every matter involves a huge number of documents, but if it does, then nobody wants to sit there and have to review 2 million documents if you don't have to. You want to cut to the chase and review 20 or 30,000 only, knowing that that pool that you're looking for is pretty close to what you're after, not just a pile of rubbish. So the studies have shown, and I won't list them here, they will be in the white paper we'll distribute, and as I said, our analytics and technology-assisted review webinar will cover this in detail. But essentially what they show is that when you're looking at trying to find relevant documents in a pool of stuff, then you're looking for both precision and recall. So precision is about finding the number of documents that you've reviewed that are actually relevant, and recall is the amount of relevant documents that you're missing and not reviewing. Now the aim is that 100% of the time you won't be missing anything. So how do you strike that balance and make sure that you're making best use of your available resources? Now it's interesting to note that in the US there are judges who are actively encouraging the use of these search tools, and Magistrate Andrew Peck in the matter of Moore and Publicis Group, and that was in the US District Court in New York back in February 2012, so 2 years ago. The magistrate there said, and the case involved one party had come up with a list of keywords which was several pages long, and in the end they actually discovered privileged documents to the other side. And of course they said, well, we discovered those inadvertently, we had all these keywords, we tried our best, but what could we have done? And the magistrate was quite critical of the way it had been done, because it was evident that despite the the volume of keyword searches that this party had come up with, they really didn't understand what they were doing. They didn't have a methodology behind the application of these keywords. And he said, well, look, you don't just come up with a bunch of keywords. There are tools out there that can really help you find what you're looking for. There are tools that allow you, once you've found your list of documents that you think are privileged, to then compare them to what's in the document set and make sure that you're not discovering other privileged documents. So I guess it was more about making sure that the lawyers understand how this works, and this can be difficult when we go through law school and don't learn anything about how this stuff works. There's not many judges who would understand any of this. So making sure that you have a good methodology, making sure that you use people who can really cut to the chase and get to the nub of what you're looking for quickly and easily is vitally important. So what the magistrate said is the bar should take away from his judgment in that matter. Computer-assisted review is an available tool and should be seriously considered for use in large data volume cases, where it may save the producing party significant amounts of legal fees and document review. And so not only are the judges in the US critical of e-discovery costs, they're very critical of that in Australia as well. Hence, in New South Wales, the judges are very loath to allow a discovery order until they've seen the evidence. I've heard discussions about, well, how can we put on our evidence without seeing the documents, and hence we need discovery beforehand. But it seems to be working okay, and I think with the judges managing it, if you do have a genuine need or a party's not providing what they need to, then the judges will certainly take that into account. So look, I mean, in Australia there's no decisions on point like there is in the US, but certainly, you know, from the lawyers that we speak to, the law firms who are our clients, I'd certainly say that the ad hoc evidence demonstrates that for large document sets, analytical tools are, you know, becoming used, if not regularly, certainly more and more. So how does it work? So I've just given you an example there of, I guess, a first cut attempt by the software to break down or group documents together by concept. Now you'll see in that first cluster we have someone called Mike Maggi, or Maggi Mike. So they're all emails by Mike Maggi, and in the top one it's emails between Mike Maggi and someone Rabarski and someone Nelson. And there's 1,167 documents in that first group, which all have a similarity rating in terms of concept of about 90%. And when won't show you the examples here, but when you look at those emails, you can actually see that Mike Maggi has been in effect flirting with Rabarski and Nelson are two other women in his office. So very quickly you can go through those 1,100 emails or so and work out that, well, depending on your case, those emails could just be rubbish, and you can mark all of those as not relevant in one foul swoop. Or, for example, if your case is about sexual harassment, then they all might be very relevant. So if you can see that, you know, if you were doing a review in a traditional sense, you'd have to trawl through the whole set of documents in order to weed out those 1,100 documents that were rubbish. Here you can do it together. So that's one example of how it works. Another one is concept searching. So here we have in our demo database the Enron data. And what it's done here is group together concepts which, based on the content of the words in every document, some phrases that it believes are conceptually similar. Now you just couldn't do this in a keyword search. So another example of this is, for example, if we're looking at certain types of documents, we'll quickly see that code words were used. So in this data set, they had codes based on Star Wars characters. So they'd have, you know, Jedi and this and that. And, you know, that just leads you down an inquiry that you might not otherwise go down if you were just doing a linear review with a bunch of paralegals in a room, because, you know, they may not be attuned to going down that path. Or, you know, if you're just going through document by document, you wouldn't get to see the whole picture. So here, if I just type in the word fraud, you can see that the other words that are conceptually similar to those are accountant, Anderson, Arthur, auditor, and so on. So again, just leads you, opens your eyes as to some possibilities there. The other thing it does is can show you duplicates and near duplicates. So here I've shown you, for example, the bottom document is what we call the master. We can see two documents are exact duplicates of each other. And then there's another 4 documents that are 80% similar to that master document. So very quickly, again, you get grouped together documents that are either exactly the same or very close to. And the other thing you can do then is actually get a comparison. Now if I just go back, you'll see the doc IDs there are the EN2040 and the EN00014, so the first document and the last document on that list. They're now compared, so we have those 2 documents compared in the software, and this is just like comparing 2 documents using the word compare function. And there you can see where the changes are. Okay, so you can see that someone's actually, you know, on forward that email, but have added their own little amendments there. Again, the other thing the technology does is, if it's used properly, gives you a statistically accurate result. And that EDRM sampling diagram that I showed you earlier goes into great detail about how you can do this. And I won't profess to understand all of the statistics, but you know, if you do want to back up what you've done and show that you're confident that the data set that you have reviewed, you found the relevant documents, it now has some mathematical basis to this, rather than just perhaps a your best guesstimate. I'll talk about a bit more about that in a moment. So obviously lawyers will say, well, if I'm using technology, I need to be sure that it's going to be as accurate as a traditional review. When we actually delve into this, and we've done quite a few case studies on comparing a traditional manual review to using technology-assisted review, we actually find that human review is actually not that accurate, because it's still subjective to the human element. And I'm sure as lawyers we've all done what we call the discovery hell, where you have to do your time reviewing documents. And sitting in a room for 8 hours a day, tired, not focused, perhaps not having the best instructions, means that you are going to miss things. So you'd hope that a technical solution is going to be better than that. But how do you prove that? How can you as a lawyer put your hand on your heart and say, we've reviewed these and everything that we've given you is relevant? So there are studies. They go into some detail about how this is done and why we're getting closer and closer to having lawyers being able to say, hand on heart, that the way they use the technology is actually better than a manual review and gives a much more accurate result. I won't go into that now, but the white paper that we'll send out with this recording does set out those studies. So please, if you're interested in this, there's lots and lots of stuff, lots and lots of reading in this area. So going back to Andrew Peck and the De Silva Moore case I mentioned earlier, he reminds everyone that the court standard is reasonableness, not perfection. He says the idea is not to make it perfect, it's not going to be perfect. The idea is to make it significantly better than the alternative without as much cost. And I guess, to use the words of Chief Justice Martin, who's the Chief Justice of Western Australia, that he would prefer to have a Holden than a Rolls Royce if it means that the litigant is going to save money and the court time is ultimately saved. Okay, so that sort of wraps up what I wanted to say about electronic discovery. As you can probably imagine, I can probably talk for days about some of these slides, but hopefully I've given you enough to whet your appetite, and there's certainly a lot more information we can provide you with. So moving now towards electronic trials. Obviously, if you prepare your discovery in electronic format, then it makes sense to prepare your witness statements and affidavits in electronic format, and to refer to the documents in the electronic format using their unique identifier that should live with a document from day one right through to ultimate appeal. And just having a simple database, it doesn't have to be used for huge matters. Matters as soon as you have even 3 or 4 volumes, and if you've got a team working on this and people who are able to log in from home and they don't have to carry folders around, you can get barristers to log in and get access to stuff. It just makes life so much easier. Be able to click on a link and see the exhibit from a witness statement or affidavit, and the judges just love it too, because it means that they don't have to carry around great lumps of hard copy. They can get the gist of the evidence very quickly and easily. You can prepare your chronologies with the documents cross-referenced to your events. As long as the doc ID is in there, everything can be really streamlined. And a well-prepared set of documents means that ultimately, if you're going to run this matter in court electronically, it can run very smoothly. So what are they? Essentially, it's just allowing the parties to present the evidence in court electronically. As I mentioned, they work especially well when parties have prepared their evidence electronically, and these days that is happening more and more. Federal Court Practice Note CM6 actually has very clear guidelines on what to do if the parties wish to run their trial electronically. So this is just an excerpt from Federal Court CM6. So firstly, you need to have gone through electronic discovery, and they have a pre-discovery conference checklist you need to go through. You need to have done everything that you said you were going to do in that pre-discovery phase. You need to, if you're going to get extra equipment and software and things in the court, then just make sure you get a provider that everyone's happy with, including the court. Look at your evidence management software that you're going to use, and the judge does need to okay that, because the judge needs to have access to that as well. Maintaining the court book is very important. I don't think I've ever done an electronic trial where the tender bundle was set at day one and didn't change. And of course, stuff has to be done very quickly, usually after hours. It has to be done outside of court time, and it has to be available and on that system as soon as court starts the next day at 9:15 or 10 or whatever it is. Transcript. You may wish to think about real-time transcript, and these days the cost of real-time transcript, which is where the text of the transcript is available pretty soon, probably 3 or 4 seconds after the spoken word, which means you can mark it up, you can copy and paste it, you can add issues, you can do all sorts of things. And the cost of that these days is generally on par with daily transcript, and if you have multiple parties in a matter, it's actually much cheaper. Hardware and software in the courtroom, courtroom operator, so do you want someone to present the evidence, and I'll talk a bit more about that in a moment. Have counsel been appraised of the need to refer to doc IDs? This is really important, firstly because that is the way everybody can find a document, either electronically or in hard copy, but also it means that the doc ID can go into the transcript, so there can be a hyperlink from the transcript to that doc ID. It also means that we have the doc ID so that the exhibit list can be kept if a document's exhibited or even marked for identification. And yeah, it just means that you can always locate a document that counsel are referring to. Because if they refer to a document in traditional sense, refer Your Honour to the letter of Jane, of Jane logs to Mary Smith dated such and such, we lose that ability to reference it properly in the electronic world. When would you use one? Well, you'd use it anytime. I mean, traditionally they have been used for the larger matters, but these days the courts are really trying to hold themselves out as being paperless. But we really won't be paperless until a lawyer can file all the documents electronically, go to the court, log on to the court system, and then present evidence that way. But it really isn't these days that much of an effort now to allow parties to present the evidence electronically. Excuse me. Sometimes the court will order the matter to be run electronically. It really depends on the judge. Some judges are very favour technology and prefer it. Other judges simply, would prefer paper. So even if the parties do wish to run the matter electronically, some judges do still insist on having their own paper versions. The good thing, though, is that many courts now have basic equipment such as cabling, internet and screens. I remember when I first set up a electronic court in, I think it was the Banco Court in Queensland, in the Supreme Court, there was one PowerPoint in the whole courtroom, which I think they used for the cleaners to vacuum the carpet. So these days it's much easier. There will be power, there will be cabling, certainly Wi-Fi, although we do tend to put, enable cabled internet into courtrooms as well so that we have that fast connection. If you want to bring in additional equipment, you'll see the photo there is one of our courtrooms where we just brought in laptops. People could bring laptops in and then connect, and away you go. Evidence management software. I'll talk about that in a moment, and then any expertise you may need in order to just make sure everything runs smoothly, including technical expertise. So an evidence management system, traditionally, there's usually been an independent system that where both parties put their respective stuff into that system and provide access to the judge. Although there is no reason why parties can't, use their own system to prepare the evidence and then present it themselves. The benefit of some of these electronic systems is that you're able to generate and keep an electronic court record. So instead of having the hard copy handed up to the bailiff or the associate and then the red stamps put on and so on, that can all be done electronically. So the idea is you have all of the information in the tender bundle, all the documents that comprise the tender bundle available. Counsel can then, by referring to the doc ID, have those documents brought up and shown to witnesses. If they're then tendered as exhibits, that can be done straight away. So in an ideal world, you'll have your exhibit list up to date to the minute. Hyperlinked witness statements, as I mentioned earlier, or affidavits, where you can just link straight to a document. Exhibits transcripts, so real-time transcript and all the historical transcript, so you can always go back to a day if it's more than a one-day hearing. And you can have anything else in there, so your pleading submissions and any other documents required. Then, of course, there's a public view where you can have a frame open through the software and see whatever counsel is referring to at the time, and that can be available from within the courtroom, or it can be made available remotely as well. Video conferencing you may need, and then technicians for technical support. I mean, I must admit, in the probably 17 or 18 years I've been involved in electronic courts, touch wood, we've been fortunate that we've never ever had any significant downtime in a courtroom. I think the most problems we do have are where people forget their passwords. So I think the technology generally does work so well, maybe because we all lie awake and that's our worst nightmare if something was to go down. So generally it does tend to run very smoothly. Having said that, now I probably have some downtime, so let's hope I'm touching wood here everywhere. So traditionally in Australian courts, we've found that counsel often prefer to have a court operator in the room to drive the evidence management system. And there's no need for that. I mean, a barrister, if they're comfortable, can actually present the evidence from, they can prepare it, they can present it, and they remain in control. So I think over the next few years we'll actually see a shift from, counsel sort of outsourcing that electronic stuff, and that just sort of operates in tandem with what they're doing, to becoming, part of the process and what they do. And it's a very, I think with counsel, it's a very specific expertise, being able to stand on their feet and cross-examine a witness. So, they have to be not only prepared, in terms of they know where their documents are, but also, mentally know where everything is. So, I think as more counsel get au fait with the systems and prepare their evidence using these tools, they'll be much more comfortable actually, presenting electronic evidence in court. So just, I guess, showing you some screenshots. I'm not proposing to do a live demo today, but if anybody would like a demo, please let us know. We can provide that. But essentially, I think the next generation of stuff that we'll see in the courtroom is, some of this live streaming. So here, I'm showing you a screenshot of This is all through the internet, so I can be sitting either at my PC in the court or at a PC in London, and I can see this. Now what I've done here is, after I did this, or just prior to taking this screenshot, I had the person on the other computer actually type this stuff out. So I said, this is being streamed from another computer and magically appearing on my computer. And as the user types this on the other computer, everyone in the courtroom can see the changes. And all of this is published using Internet Protocol and not using what we call dumb terminals. So even if the user's in London, they can see this live. Now, I've used a spreadsheet here because this is particularly beneficial. You know, you may have witnesses giving evidence where they've got a spreadsheet, but you want them to tell you how calculations were done, or you may wish them to change it so that you can see how the changes are made. All of this is now possible through the internet, not just through what we call a dumb terminal, so you just see what, you know, the screen the witness is seeing, but done live, anywhere, anytime. So this is the power of the internet, and you know, our kids do this every day, and that's what they'll expect of courts in years to come. So, as I say, the technology is the easy part. Real-time transcript can be streamed. For those of you who haven't seen it, I've just done a bit of a snapshot here. So I've opened up a real-time window here, just a demo version, and you'll see here we've got page 1, it goes down to line 13, and I did that at 9:56 p.m. And then I waited a minute later, and you can see that the text has now gone down to line 25, and that's 9:57 p.m. So that will actually, you know, come up and fill up those lines as you go. On the right-hand side here, I have all of my issues. So if I want to mark up passages of text with issues, I can actually do that live in the courtroom. Now, anyone who uses this just loves it because it means that all your notes are done. You can just review the transcript and review your notes that day. You don't have to wait madly for the transcript to arrive at 6:30 at night and then start reading it. You know, it's more of a review and a catch-up. Publishing to documents, as I mentioned, you know, you can publish documents to all users, or you can publish documents to certain users. So, for example, you know, the associate may just want to publish a particular document to the judge, or you may have a junior just wants to publish a particular document to their own counsel, so they can read that and think, oh, okay, I actually need to you know, cross-examine on this. So it's published to them, and then they can go and publish it to all if and when they're ready. So here I've just got on the left-hand side a publish to all button, or you can actually select a particular user that you want to publish to. Now here I just wanted to show you that, and it might be a bit small, but this is what the publish view looks like. You can maximize that so that the screen on your computer just shows you the document that everyone is looking at in the courtroom, or you can have on the left-hand side your own metadata, or you can make your own annotations and notes on the document as you go. All of those notes will be made private to you unless you want to share it with other people in your group. The other benefit of this technology is that if that document is published and you have made your own notes on that document, you'll have those available to you. So you can go, be sitting there half asleep and the document will be published, and you'll look at it, see your notes and go, oh my God, that's a really important document. Counsel, have a look at this. This is what you need to be looking at. So all of that handing around of paper with post-it notes and scratching around trying to find that goes away, because you know, you think about a particular word, you can search across it in the database. You call up a document, you have your highlights there that you made last week. You know, often trying to do that in hard copy, you have to know exactly where it is in the hard copy. Here you can be a bit lazier because you've got the whole, you know, search capability behind you, plus all your available notes and so on. Now I've just shown, if I go back to the previous slide, and it might be a bit hard to see, but you'll see the heading of that document is Contacts for Connolly Logic. Now what I did was I published that, or I accessed the system on my iPad, and just took a photo of it so that you can actually see that I'm looking at the same document on my iPad. So I can be sitting in court just doing stuff on my iPad, or I can be back at the office, or I could be at home on the couch just watching what's going on in court. You can have a list of all the documents that have been recently published. So you think, oh yeah, look, they referred to a document a couple of hours ago. Which one was that? There it is. Click on that and you can have another look at it. You can have the up-to-date exhibit list at your fingertips, and you can export those. So in the software, here's the exhibit list. If I click on that export button where the red arrow is, it exports to a spreadsheet for me. I can save that, I can do stuff to it, I can send it back to the office, whatever I need to. Affidavits and witness statements have hyperlinks directly to the exhibited document. So for example, here I've just given you a snapshot of what's contained in an affidavit. If I then click on that, you'll see the actual document appear in its own separate window, and again with any notes and issue coding and so on that you might have made. Historical transcript can be stored, can be searched, can be marked up, anything else you need to do with that. And then, of course, all documents can be annotated, redacted, and all have your own stuff available there as well. Can I still have paper? Absolutely. And the use of the unique doc IDs means that hard copy can always be referenced back to an electronic version. And if counsel prefers, a brief to be numbered sequentially, that can be done, of course. Just ensure that that doc ID remains on it. So when in court, that document is always referred to. So just summing up, I think we've gone for about 50 minutes now. So just wrapping up, I just wanted to highlight to you what's going on in the UK. So Richard Susskind, who you may or may not have heard of, has written several books on the future of the use of technology in the law, and has made certain predictions, some of which have come true, some of which we're still catching up with. But he sat on a committee, the Civil Justice Council, which has recommended that an internet-based court service be run by the government to handle low-value claims. And low-value claims are those up to £25,000. Now that report draws on examples such as eBay, which settles around 60 million disputes between traders each year, and which are resolved either through online negotiation between the parties or where a binding decision is made by an eBay staff member. Interesting. So Richard Susskind said, this report is not suggesting improvements to the existing system. It's calling for a radical and fundamental change in the way that our court system deals with low-value civil claims. Online dispute resolution is not science fiction. There are examples from around the world that clearly demonstrate its value and future potential, not least for litigants in person. So I guess that's interesting. We'll see how that goes. I mean, certainly from a technical perspective, all of this is really easy. I guess there's some of the other issues that need to be addressed before that can be fully implemented. All right, well, look, we're running pretty close out of time, but I've probably got time for a couple of questions if people want to just type those into the frame. Otherwise, there are my contact details. Please feel free to send me an email if you have any questions. Okay, so I've got a question up. How widely are e-trials used in Australia? I think they're being used more widely. As I said earlier, I've been doing this a long time. And I think years ago there was probably 1 or 2 trials a year. Now I'd say there's closer to 6 or 7, certainly just in Sydney. And I think I think the biggest thing is that the courts are more willing to support them. The courts now have a lot more equipment, so I think that we will see a lot more of them in the immediate future. Next question is, will a copy of the slides be emailed to us? Yes, we will email those to you, and as I said, there's a couple of white papers I'd like to go with the slides as well. All right, so unless there's any more questions, thank you very much for attending. I hope you found it interesting. Certainly, please provide any feedback. We always find that valuable. Yeah, and again, if you have any questions, just send an email through. But thank you and enjoy the rest of your day.